Okay, let's take a deep breath and really picture this. We're stepping inside a courtroom. Sydney, August 2009.
Right. The atmosphere, you can imagine, it's incredibly tense.
And there, in the dock, isn't some seasoned criminal. It's a boy. He was only 15 when the crime allegedly happened.
15. A refugee kid who'd come to Australia looking for safety.
And now he's facing maybe the most serious charge possible. Murder. Something that could just wipe out his entire future.
The prosecution, the Crown, they're arguing that this young man, he's known only as JB in the proceedings, his identity is protected.
Because he was minor.
Exactly. They're saying he was the one responsible for fatally stabbing an innocent man during a street fight the year before.
Okay, so that's the accusation. But what's the proof? What's the prosecution hanging their hat on?
Well, it comes down to a confession. That's what they say is the clincher.
A confession, okay, but not one given to police during formal questioning, right?
No, that's the twist.
Yeah.
This confession was supposedly made sort of quietly, maybe vulnerably.
To who?
To the person who was meant to be there supporting him during the police interview. His independent juvenile support person.
The adult who's supposed to look out for a kid in that situation.
That's the role. But here's where it gets really disturbing.
Okay.
That independent support person, he wasn't just some concerned volunteer picked at random.
No.
He was secretly working for the police, a registered police informant. His code name in the case files is A107. His identity is suppressed too.
Wait, so the kid's support person was actually a police informant?
Yes. And his real connection to the police, the fact he had his own criminal history, the very strong reasons he had to give testimony that helped the police.
Like getting a better deal for himself.
Precisely. All of that was kept hidden, completely hidden from JB's lawyers, from the judge, from the jury.
Wow. Okay. So that's what we're diving into today. We need to unpack how this secret, this fundamental deception, really.
And what the sources call serious ethical failures by the prosecution.
Yeah, how that all led to JB being wrongly convicted and spending. How long was it?
Almost 7 years. Nearly 7 years of his life locked up.
This isn't just some abstract legal argument then.
No, not at all. This is a true crime story. It's about real lives getting shattered, years lost forever, a family's faith in justice just gone.
And it also led to a respected senior prosecutor facing serious professional consequences.
That's right. It's a story with huge implications.
And we're basing this whole deep dive just on the source material provided to us, including the official findings from the disciplinary case against that prosecutor.
Yes. The case is Counsel of the NSW Bar Association v. Thorpe.
And it really stands out as a cautionary tale, doesn't it? Especially for anyone listening who's thinking about a career in law.
Particularly if you're thinking about becoming an advocate, a barrister, maybe even a prosecutor. It forces you to ask, how could this happen?
And what does it mean for your ethics, your responsibilities, if you go down that path? How do you make sure you don't make these mistakes?
It's a heavy question. To understand it all, we need to know who was involved. Let's quickly introduce the key players based only on what the sources tell us.
Okay, let's do that. The central figure, obviously, is JB.
The 15-year-old South Sudanese refugee accused of murder, wrongfully convicted, as we now know, spent almost 7 years in jail before being cleared, name suppressed.
Then there's the victim of the original crime, Edward Spowert.
A 54-year-old man, just an innocent bystander caught up in that street brawl in Granville. His tragic death started this whole chain of events.
And the source of the secret? The man at the police station. Witness A107.
Posed as JB's support person. Claimed JB confessed to him, but secretly he was a registered police informant.
With his own criminal record for fraud.
Right, and he was looking for leniency on those charges. Became an informant during the murder investigation, got a sentencing discount for his help, all hidden at the time, name also suppressed.
The prosecutor leading the case against JB was Terrance William Thorpe, usually known as Terry Thorpe.
A very experienced Crown prosecutor. 26 years at the bar when JB's trial happened, led the prosecution team, and later he was the one facing the disciplinary proceedings for professional misconduct.
The sources say he was seen as a respected prosecutor, no prior issues.
That's what they indicate, yes. An otherwise clean record before this case.
Okay. And who was representing JB at the trial? His solicitor.
Identified only as DWO, also suppressed. And here's another layer. The sources mentioned DWO had actually represented A107, the informant, in some other unrelated criminal matter shortly before JB's trial.
Really? That seems complicated. Did DWO know A107 was an informant from that?
The sources don't really explore that angle or what DWO knew. The focus is squarely on what the prosecution knew about A107 and failed to disclose. But it's certainly a strange connection in the background.
Definitely adds a wrinkle. Okay, and then later, in the disciplinary case against Thorpe.
You had the lawyers for the NSW Bar Association, the professional body. They were led by M. Johnston SC, instructed by the firm McCullough Robertson. They essentially prosecuted Thorpe for misconduct.
And defending Thorpe.
His team was led by P. Menzies, QC, and B. Nolan, instructed by Nolan lawyers. And just quickly for listeners, SC and QC are titles for senior, highly experienced barristers, Queen's Counsel or Senior Counsel.
Got it. So those are the main people involved. Now let's go back to the very beginning, the crime itself.
Okay. We're in Granville, Sydney, April 2008. Late at night.
Describe the scene.
Chaos. A street fight breaks out between two groups of young men. It's messy, violent.
And Edward Spoward, just a bystander.
Yeah, tragically, he's just in the wrong place at the wrong time, gets caught in the middle of it all, and is fatally stabbed.
Police arrive, investigate, and suspicion falls on JB. He's arrested. How old was he again?
Just 15. Still legally a child.
So, at the police station, because he's a minor, facing such a serious charge.
The law is very clear. He's entitled to have an independent support person present during questioning. It's a safeguard.
And the police call in A107 to be that person.
That's right. They arrange for A107 to come to the station. And to JB, this scared 15-year-old, A107 must have seemed like, well, like the designated safe adult in the room, someone there to help him.
But he wasn't. That's where the secret starts.
Exactly. He's secretly working with the police. And according to A107's later testimony, it was during this time at the station, while he was supposedly acting as JB's supporter, that JB allegedly made incriminating statements to him. Statements that amounted to a confession to the stabbing.
A confession obtained by a police plant acting as a support person.
Precisely. And this alleged confession became, as the sources put it, the crown jewel for the prosecution. It was their strongest piece of evidence directly linking JB to the killing.
And A107 had his own reasons for wanting to provide this helpful testimony.
Oh, very clear reasons. The sources spell it out. He was facing serious fraud charges himself. Big trouble.
So he was looking for a way out.
He was looking for leniency, a lighter sentence.
Yeah.
And he became a registered police informant while the investigation into Spoward's murder was happening.
Specifically to help with this case.
Yes, angling to get credit, to get a sentencing discount on his own fraud charges by helping the police secure a conviction against JB.
And did it work? Did he get that discount?
He absolutely did. The sources confirm it. A senior police officer from the JB investigation actually filed a formal document, an affidavit of assistance, in A107's own fraud case.
What did that affidavit say?
It specifically praised A107 for his help in the JB murder investigation.
Boy.
And then in September 2008, this is months before JB's trial even began.
Right.
When A107 was sentenced for his fraud, the court explicitly gave him a discount on his sentence because of his assistance in the JB case. He got a tangible benefit. Less jail time for himself.
So let's be crystal clear. The prosecution's star witness was a registered police informant with his own criminal record who had already been rewarded by the system for helping build the case against JB.
Correct. A huge motivation to testify in a way that pleased the prosecution. And this directly affects his credibility, doesn't it? Makes you question everything he says.
Absolutely. But crucially, at the time of JB's trial, did the defense know any of this?
No, nothing. They didn't know he was an informant. They didn't know about his criminal history being given to the prosecution. They didn't know he'd already been rewarded for his help. Complete darkness on these critical facts.
And that lack of knowledge would be devastating. Which takes us to the trial itself, the first formal court stage.
Yes. August 2009, NSW Supreme Court. Justice Megan Latham presiding with a jury. This is procedural step 1, the trial.
And the legal teams again. Crown Prosecutor Terry Thorpe with instructing solicitor Julie Davis.
For the defense, JD's counsel, who isn't named, and solicitor DWO.
And we have that background detail about DWO having previously acted for A107. Still feels relevant, even if the sources don't focus on it.
It's a background note, yes. But the key point remains. The defense team as a whole was unaware of A107's true status and his deal.
So Thorpe's prosecution strategy heavily relied on A107's alleged confession.
Massively. The sources indicate the rest of the evidence was pretty shaky. Circumstantial, contradictory stuff.
Wasn't there another witness mentioned? Ringo.
Yes, Ringo. He also testified against JB, but apparently only after alleged police pressure. And interestingly, he also received a reduced sentence on his own charges after cooperating.
So multiple key witnesses seem to have had incentives to help the prosecution.
It certainly paints that picture. It suggests that without A107's supposed confession, the Crown's case might have been very weak indeed.
Okay, so before the jury could even hear about this confession, there was a legal argument about whether it should be allowed in.
That's right. Of voir dire. It's like a trial within the trial, just before the judge, no jury present.
And the defense argued against letting the confession in.
They did. They argued based on JB's young age, his vulnerability, and A107's role as this supposed support person. You know, questioning if anything said in that context could be truly voluntary or reliable.
But they were arguing with one hand tied behind their back.
Completely. They couldn't make the most powerful argument that this support person was actually a police agent with a criminal record who had already been paid off, essentially, for his help. They didn't have the ammunition because it was hidden.
So without that crucial information,
Justice Latham ruled the statements were admissible. A107 could testify about the alleged confession.
and did the jury get told who A107 really was?
No, absolutely not. That was the core of the problem. He appeared to the jury as just a concerned member of the community who happened to be there as a support person and heard something incriminating. Credible. Independent.
Which was completely false.
Utterly false.
And with that seemingly credible confession, evidence admitted.
The jury convicted JB of murder September 10th, 2009.
Then came the sentencing, May 2010.
Justice Latham sentenced him to 23 years in prison, minimum of 16 years before he could even apply for parole.
16 years minimum for a kid who was 15 at the time of the crime, based on evidence that was fundamentally misrepresented.
It's staggering. From the prosecutor's viewpoint, then, maybe it looked like job done. Justice for Mr. Spowert.
But the reality.
The source material puts it bluntly. Justice had not been served. It had been subverted. The conviction was built on secrets. A107's informant status, his record, his reward, all concealed, described later as clear failures of the prosecuting authority.
But at that moment, nobody in the courtroom, apart from those involved in hiding it, knew the full story.
No, the truth was still buried.
But JB didn't give up. The next stage was appeals, right? Procedural step 2.
Correct. His case went to the NSW Court of Criminal Appeal, the CCA, in 2012. JB would have been about 18 by then, still insisting he was innocent.
And one of his main arguments on appeal must have been about the confession, challenging the decision to let it in.
Yes. The admissibility of the statements to A107 was definitely a key ground of appeal. But here's the problem again.
The CCA judges didn't know the truth either.
Exactly. Just like Justice Latham and the jury, the CCA judges were reviewing the case based only on the information presented at the original trial. The secret about A107 was still a secret. They had no idea.
So they were looking at the same flawed picture the jury saw.
Right. And based on that limited, misleading picture, a majority of the CCA judges dismissed his appeal in early 2012. The conviction stood.
So the CCA wasn't the end of the road. This is the High Court. Procedural step 3.
Yes. The defense applied for special leave to appeal to the High Court of Australia. That's the highest court in the country. But they only agree to hear cases they think involve important points of law or where there's been a clear injustice shown on the record.
And did they take JB's case?
No. In 2013, the High Court refused special leave.
So from a legal standpoint,
The door seemed slammed shut. The source says it's seemingly closed the door on JB's direct appeals. He'd run out of standard options, still in jail.
it's chilling to think about that period. And later, one of the judges who heard that CCA appeal actually spoke out, didn't he, after the truth emerged?
Yes, retired Justice Anthony Wheely. He was on that 2012 CCA panel. Years later, knowing the full story, he called it a terrible situation. He said JB spent almost 7 years locked up because of a confession that should never have been allowed into evidence.
Strong words from a judge who was involved.
Very strong. He explicitly blamed the failure to disclose A107's status, called it a serious dereliction of duty by the prosecution.
And he thought it would have changed the outcome back in 2012.
Unequivocally, he said if the CCA had known the truth then, the appeal would have taken a completely different course and would have resulted in the conviction being overturned, probably leading to an acquittal right back then.
So potentially years of JB's wrongful imprisonment could have been avoided if the truth had been told earlier.
That's exactly what Justice Wheely implies. It highlights the profound impact of that initial non-disclosure.
But in 2013, that insight was years away. JB was still inside. His family must have been desperate.
Absolutely. Imagine their situation. They'd sought refuge in Australia, trusting the justice system, and now their young nephew was imprisoned, based on what they felt was a deeply unfair process. Their faith was just eroding.
But then things started to shift. Whispers of new information?
Yes, by 2014, something started to stir. Enough information surfaced, or enough questions were raised, that JB's legal team took a really unusual step.
What was that?
They made an application to the NSW Attorney General. Not a standard court appeal, but an application under a special law, Section 78 of the Crimes Appeal and Review Act, 2001.
Section 78. Why is that extraordinary?
Because it's a mechanism of last resort. It's used when all the normal appeals, right up to the high court, have failed, but significant new evidence comes to light suggesting there might have been a miscarriage of justice.
So it's like a safety net for when the system might have gotten it wrong based on hidden or later discovered facts.
Exactly. It allows the Attorney General, the state's chief law officer, to refer a case back to the Court of Criminal Appeal for another look, based on that fresh evidence. It's a plea for a second chance when the standard path is blocked.
And this application actually led somewhere.
It did. It triggered an inquiry. In September 2014, Supreme Court Justice R.A. Holm was appointed to conduct this Section 78 inquiry into JB's conviction. And this is where the whole thing finally unraveled.
The inquiry dug up the truth.
Yes. Justice Holm's investigation confirmed it all. A107 was a registered police informant, and crucially, they found proof he was formally rewarded for helping convict JB. That 2008 affidavit of assistance surfaced the one used to get him a discount on his fraud sentence.
Okay, so the informant status and the reward were confirmed. But did they find out how it was kept secret? Was there proof of deliberate concealment?
Yes. This was perhaps the most damning discovery. The inquiry got hold of the original handwritten notes from that key pretrial meeting back in July 2009.
The meeting between Thorpe, his solicitor, Mrs. Davis, and A107.
That's the one. And those handwritten notes were explosive.
What did they say?
They showed A107 was surprisingly open in that meeting. He apparently said things like, "I'm registered informant." He confirmed he had a criminal record.
He told the prosecutors directly.
According to these notes, yes. He even mentioned that JB's own solicitor, DWO, was his good mate and supposedly already knew A107 had information on JB.
Okay, so the prosecutors knew, straight from the witness's mouth, that he was an informant with a record.
It appears so, based on these notes. But here's the critical comparison. Remember, the defense was given a typed summary of that meeting, not the handwritten originals.
Yes.
Well, that typed summary provided to the defense was missing all those crucial admissions. The phrases, "am registered informant," the mention of the criminal record, gone.
Edited out.
The sources state the typed notes appear to have been edited specifically to remove the very information that destroyed A107's credibility and revealed his police connection.
That sounds deliberate. Was there proof Thorpe knew about this editing and non-disclosure?
There was. An email chain from the same day as that meeting, July 27, 2009. It sealed it.
What did the email show?
Miss Davis, Thorpe's instructing solicitor, emailed him asking directly if she should leave certain things out of the notes for the defense. She specifically listed A107's views on who might swing, his comment about telling DWO his criminal record, and that he is an informant.
She asked if she should leave all that out. And Thorpe's reply?
His reply was just 2 words. Seems fine.
Seems fine to leave out that the key witness is a police informant with a record.
That's what the email exchange indicates. Then Miss Davis followed up, asking if she could serve the notes as is, meaning the edited, typed version.
And Thorpe?
He replied, "I think you can serve the notes as they are." Clear instruction to serve the edited version, knowing what was omitted.
Wow. Any more emails?
Yes. Mrs. Davis then forwarded Thorpe another email. This one was from the police. It included A107's full 10-page criminal history, and police confirming A107 was an informant, specifically for police at another station.
So, explicit police confirmation he was an informant. What did Davis ask Thorpe then?
She asked if she should make further inquiries about his informant status or serve the criminal history.
And Thorpe's response this time? Did he say, yes, we need to disclose this?
No. He replied, "No, I don't think so. Public interest immunity and all that stuff." And added something about being satisfied A107 wasn't known on our system, which seems to ignore the police confirmation he was known as an informant elsewhere.
Invoking public interest immunity, PII. That's usually about protecting sensitive police methods or ongoing investigations, right? Not usually for hiding the basic fact that your witness is an informant, especially when he told you himself.
Exactly. It suggests he was thinking about reasons not to disclose rather than fulfilling the duty to disclose. The justification seems weak, given A107's own admissions and the police confirmation.
So this email chain, discovered years later, basically proved Thorpe knew A107 said he was an informant, knew the notes were edited, knew police confirmed it, and still made the call not to tell the defense or the court.
That's what the evidence uncovered by the inquiry strongly suggested. It was the smoking gun.
What did Justice Holm do with this finding?
He completed his Section 78 inquiry and formally referred the case back to the Court of Criminal Appeal. He pointed out how heavily the original conviction relied on A107's testimony, which was now shown to be based on concealed facts.
Which leads us to procedural step 4, the final appeal.
Yes. A fresh appeal hearing before the CCA, but this time, finally, the court had the full story. This was April 2016. The case is known as JBVR No. 2.
And the outcome this time, with all the facts on the table?
Swift. Decisive. The CCA quashed JB's murder conviction.
Just like that, based on the non-disclosure.
Yes. Chief Judge Hoban, giving the judgment, was clear. Once you removed A107's tainted testimony because the non-disclosure made it completely unreliable and likely inadmissible.
What was left?
The remaining evidence against JB was, in the Chief Judge's words, woefully insufficient to prove guilt beyond reasonable doubt. Too weak.
Not even enough for a retrial.
No. The court found the remaining evidence was so lacking, there was no point putting JB through another trial. They ordered an immediate acquittal.
Acquittal. Meaning legally innocent.
Legally innocent. After almost 7 years in prison, finally free.
How did his family react? Relief, obviously.
But bittersweet, as you'd expect. Immense relief, his name was cleared, but also profound sadness and anger over the lost years and the trauma.
His uncle's quote was powerful.
Yes, he said, "What has happened to my nephew is something unbelievable. He's an utterly broken man." Their faith in the system, the source says, was destroyed. But his name was cleared. That was huge.
So JV is free. But the story doesn't end there. The focus shifts to accountability. How did this happen? How did the system fail so badly? Attention turns to Terry Thorpe.
Right. And this is where the system starts to look inwards. Procedural step 5. The DPP gets involved.
The Director of Public Prosecutions, Thorpe's own employer at the time.
Yes. In September 2016, just months after JB's acquittal, the head of the DPP, Lloyd Babb SC, took a really significant step.
What did he do?
He wrote formally to the Office of the Legal Services Commissioner, the OLSC. That's the independent body that handles complaints against lawyers in NSW.
And the DPP's letter.
It flags serious concerns about Terry Thorpe's conduct in the JB case. It essentially asked the OLSC to investigate whether Thorpe's actions amounted to professional misconduct.
So the prosecution service itself initiated the complaint against one of its own senior prosecutors.
Yes. A very unusual and important step, showing a commitment to addressing the failure internally.
So that kicked off the formal disciplinary process against Thorpe.
It did. Late 2016, the OLSC started a formal complaint based on the DPP's referral. Because Thorpe was a barrister, the complaint was then passed to the NSW Bar Association Council, the governing body for barristers.
And the Bar Council decided to proceed.
They reviewed the evidence that came out in the Section 78 inquiry, the notes, the emails, and they resolved to bring formal disciplinary proceedings against Thorpe in the tribunal.
Did Thorpe stay at the DPP during this?
No. Around this time, in July 2017, he resigned from the DPP. He went back into private practice, but working as a defense barrister.
Okay, so the Bar Council files the case. Procedural step 6, the tribunal hearing.
February 2018. The Bar Council, represented by M. Johnston, SC, filed the formal application against Thorpe in the NSW Civil and Administrative Tribunal NCAT's Occupational Division. That's the court for lawyer discipline.
And what were the specific allegations?
Initially, there were 6 grounds listed. Breaches of specific barristers' rules, we'll get to those, plus broader allegations of misleading the defense and misleading the court.
But wasn't there a hiccup? A delay?
Yes, an initial procedural problem. The first application hit a snag due to a technical issue with how the authority was delegated from the OLSC to the Bar Association. It wasn't about the substance of the case, just a legal technicality.
So the first case was dismissed?
It had to be, yes, in October 2019. But the complaint itself wasn't dead. The Bar Council fixed the technical delegation issue and filed the application again in April 2020, making sure it was legally sound this time.
Got it. So the proper hearing finally happened when?
August 2020, before a 3-member panel at NCAT. The case name: Council of the NSW Bar Association v. Thorpe.
Okay, let's talk about those ethical rules Thorpe was accused of breaking. These are really the core of the cautionary tale for lawyers, right? especially prosecutors.
Absolutely fundamental. Prosecutors have a special role. They're sometimes called ministers of justice. Their job isn't just to win, it's to help the court find the truth fairly.
So which rules were key here?
Okay, first, Rule 62, the duty of fairness. This says a prosecutor must fairly assist the court to arrive at the truth and seek impartially to have the whole of the relevant evidence placed intelligibly before the court.
Impartially place the whole evidence. And the tribunal's finding on this?
They found Thorpe breached it by not telling the defense or court that A107 said M registered informant, by not revealing the handwritten notes, by not disclosing the editing of the typed notes, by not sharing the police confirmation. He clearly did not fairly assist the court. He actively withheld crucial parts of the evidence.
Okay. What was the next rule?
Probably the most important one here. Rule 66, the duty of disclosure. This is often called the prosecutor's golden rule.
Golden rule. Why?
Because it mandates disclosing all material evidence relevant to guilt or innocence to the defense as soon as possible. There are very few exceptions.
And information about your star witness being a paid informant with a record, that's relevant.
Extremely relevant. It goes right to credibility, reliability, maybe even admissibility. The tribunal found Thorpe's failure to disclose A107's informant status, his criminal history, and the reward he got was a clear, serious breach of Rule 66. He kept vital information from JB's lawyers. That undermines the whole idea of a fair fight.
Makes sense. Was there another related rule?
Yes, Rule 66A. This one said that even if a prosecutor thinks they have a valid reason not to disclose something under an exception,
Like the PII argument Thorpe raised in the email.
right, even then, the prosecutor must stop and consider. Could the defense be unfairly hampered by this non-disclosure? And if so, should the charge maybe be dropped or reduced because the trial won't be fair?
It's like a final check. Am I being fair, even if I think I have a technical reason not to disclose?
Exactly, a crucial safeguard. The tribunal found Thorpe breached this too. He failed to consider how badly JB's defense would be damaged by not knowing about A107. He just pushed on, keeping the secret, without apparently weighing the fairness implications.
Were there other rules mentioned?
There was an initial charge under Rule 67, which deals with calling all credible witnesses and not suppressing evidence helpful to the defense. But the Bar Association actually withdrew that specific charge during the hearing, so the tribunal didn't rule on it.
Okay. But the overall pattern seems clear. What about the general charge of just misleading people?
Yes, beyond the specific rules, there was the broader allegation of misleading the defense and the court.
How did they find he did that?
By giving the defense those edited typed notes as if they were the complete record, that was actively misleading. And then, by simply staying silent about A107's true status throughout the whole process, he allowed everyone, defense, judge, jury, to operate under a false assumption about his key witness. The tribunal found this was proven. His omissions, his silence, actively misled. It strikes right at the duty of honesty.
Faced with all this evidence from the inquiry, the notes, the emails, how did Thorpe respond in the tribunal? Did he fight the charges?
No, he didn't contest them. Instead, he filed what's called an instrument of consent. Meaning he formally admitted the main facts laid out by the Bar Association. He admitted his conduct in the JB case amounted to professional misconduct under the law. They agreed on a statement of facts, so there was no need for a full trial debating what happened. He essentially conceded he'd breached his duties.
So the tribunal's job was then mainly to confirm the findings and decide the penalty.
Correct. They issued their decision in November 2020, formally found Thorpe guilty of professional misconduct on those 4 counts, breaching Rule 62, 66, 66A, and misleading the defense and court.
And the penalty for these serious breaches that contributed to a 7-year wrongful imprisonment.
The penalty imposed was a reprimand.
A reprimand. Can you explain what that means in practice? For some listeners, it might sound light.
I understand why it might seem that way. It's not suspension, it's not being struck off. But in the context of professional discipline for a senior barrister, a reprimand is still a very significant finding. It's a formal, public condemnation by his professional body and the tribunal. It goes on his permanent record. It signals that his conduct fell seriously short of the required ethical standards.
Did the tribunal explain their reasoning for choosing a reprimand?
Yes, they considered mitigating factors. His otherwise clean record over many years, his cooperation in the disciplinary process by admitting the misconduct, and the long delay between the events in 2009 and the final decision in 2020. They also ordered him to pay the Bar Association's legal costs.
And the purpose isn't meant to be purely punishment.
No, the tribunal emphasized that disciplinary orders are primarily protective and deterrent. protecting the public, upholding professional standards, and deterring other lawyers from similar conduct. The reprimand publicly declares that Thorpe's actions suppressing truth, breaching fairness and disclosure, misleading, were unacceptable and compromised the integrity of justice.
It's a formal stain on his record.
A significant mark, as the sources put it, and a powerful reminder, really, that even experienced lawyers can falter, and the consequences can be absolutely devastating.
Which leads us right into the lessons from this whole story. This is the core message, isn't it? Especially as a cautionary tale.
Absolutely. If there's one case aspiring lawyers, especially barristers, should study for ethics, this might be it. It's a sobering message, a potent cautionary tale.
It shows how one bad decision,
The single decision not to disclose the truth about A107.
just snowballed. It cascaded into tragedy.
The human cost is just immense. JB losing 7 years, his family's trust destroyed, public confidence shaken by this clear miscarriage of justice stemming from failures of the prosecuting authority.
So for you listening, maybe dreaming of wearing the wig and gown or already starting out, these rules aren't just exam fodder.
Not at all. Rule 62, Rule 66. Fairness, disclosure, honesty. They are the absolute engine of a fair trial. They're the safety valves meant to protect innocent people, to make sure the courts are legitimate.
And Thorpe's case shows what happens when those valves fail or are deliberately overridden.
It's not abstract, it's real people. An innocent person jailed. The guilty person, whoever stabbed Mr. Spowert, possibly never faced justice because the original case was flawed. And the whole profession takes a hit to its reputation.
It's worth noting, though, that the system did eventually uncover the truth, right? It took way too long, but it got there.
Yes, and that's important too. It took the persistence of JB's lawyers, the meticulous work of Justice Holm in the inquiry, the judges on the CCA in 2016, the DPP himself referring Thorpe.
And the Bar Association pursuing the discipline.
Right. It shows the system can self-correct, but it relies on individuals having integrity and doing the right thing, sometimes in difficult circumstances like the DPP investigating his own team. It relies on everyone playing their part ethically.
And it's important not to paint Thorpe as just a one-dimensional villain.
Yeah.
The sources mention he was respected, no prior issues. It makes you wonder how it happened.
You can only speculate, of course. Maybe it was cognitive bias, maybe tunnel vision. Perhaps he became so convinced JB was guilty that he started rationalizing, thinking, well, disclosing the stuff about A107 won't change the ultimate truth as I see it, so why risk collapsing the case?
But that's exactly the danger the rules are designed to prevent.
Precisely. The rules exist because we know people can develop tunnel vision. The principle has to be, the ends do not justify the means. A prosecutor's job is justice, not just convictions. That means presenting all the relevant evidence fairly, even, or perhaps especially if it hurts your case.
Okay, let's make it really concrete for someone listening. Imagine you are that junior prosecutor back in 2009. You're in the room. You hear A107 say, "Clear as day, I am a registered informant." What do you do? What must you do?
The ethical path, illuminated by this case, is crystal clear. You must ensure that information is disclosed to the defense. Full stop. No ifs or buts.
Why?
Because it's directly relevant. It goes to the heart of the witness's credibility. It affects the reliability of the evidence. It potentially affects whether the confession is even admissible. It has to be disclosed.
Even if you think, oh no, this could sink our case.
Especially then. If disclosing the truth might sink your case, it probably means your case isn't strong enough without relying on hidden or tainted evidence. Your duty isn't to prop up a weak case by hiding things. It's to pursue justice fairly.
And what if?
What?
What if a senior colleague tells you to keep quiet? The pressure.
That's the hardest test, isn't it? But your ethical duty, your primary duty as a lawyer, especially as a prosecutor, is to the court and the administration of justice. That duty overrides instructions from a superior if those instructions are unethical. You have to find the courage, respectfully but firmly, to say, no, we can't do that. We have a duty to disclose. That duty is your shield and your obligation.
This case really is like a real-world ethics exam, isn't it? A parable.
It truly is. It shows a trial isn't a game to win at any cost. It's a search for truth, governed by strict rules of fairness and honesty. When you try to win by ambush, by concealment, you create injustice. And eventually, as happened here, the truth tends to come out.
And when the truth came out, the CCA was clear. Without A107's tainted evidence, the case was woefully insufficient.
The truth prevailed. JB walked free. And the profession formally condemned the actions that kept him locked up.
So the final message for anyone in or entering the legal profession.
Cherish your ethical obligations. Guard them. They aren't burdens. They are the foundation of justice itself. The trust placed in lawyers, especially prosecutors, is enormous. Never lose sight of that. Because as this case shows, the consequences of ethical failure can be catastrophic for others and for yourself.
Honesty, fairness, disclosure, above all else.
Above the desire to win, above ambition, justice demands it.
A truly stark and necessary reminder. Which leaves us with something for you, our listener, to think about. We see the immense pressure here. How can professionals, not just in law but in any field demanding integrity, actively build and maintain the ethical courage to do the right thing, especially when it's hard, when it goes against the grain, or when there's pressure to look the other way? How do you make sure you're ready for that moment?
That's a question that requires ongoing reflection, doesn't it, in any career?
It certainly does. Thank you for joining us for this deep dive into what is a very difficult but incredibly important case study.